Good evening, everybody, and thank you all for taking out the time to be here. So we'll start, Gurpreet. Yeah. So as you all know, the theme and the topic for today is use of AI and technology in law and legal practice. So we are going to be talking about bar leadership in new age, integrating AI in actual everyday practice, how AI is actually transforming the legal profession all over the globe, but especially in UK and in India. And finally, some tips on how some skills can be adopted in practicing AI for all of us lawyers here. So we are joined by King Counsel Barbara Mills, who's sitting just next to me. She's the chair of the Bar Council of England and Wales. We also have with us Baljinder Bhatt. She's a barrister at London. And we also have with us our very own Gurpreet Singh Kalo. He's an advocate at Punjab Haryana High Court with more than 10 years of experience in litigation, special focus on IP and tech. So speaking of AI and integrating it within our courts, there are always certain inhibitions, I feel, but at the same time, there is also a desire to imbibe within our working recent tech and AI-driven models. So while on one hand, our Supreme Court, the Supreme Court of India has constituted an AI committee, and the erstwhile Chief Justice of India, Justice Bobde, has even launched an AI-based portal called SUPACE, which stands for Supreme Court Portal for Assistance in Courts Efficiency for the Judiciary. On the other hand, the present Chief Justice of India has recently voiced his apprehension on the use of AI. In fact, he's cautioned against integration of AI and judiciary and said that it must be used cautiously. One of the very notable points, in fact, that he brought up was that the essence of justice involves empathy and ethical considerations which remain beyond the reach of algorithms and AI. So talking of AI further and how we can integrate it valuably in the legal profession by us lawyers and budding lawyers, I want to initially start by categorizing us professionals broadly in two categories, two categories that just came to my head. One would be the category of thinkers, thinkers who originate complex ideas and arguments and build them from first principles of law and prepare a first draft of pleadings. These could be fresh graduates, younger generation of lawyers, who are the ones that are drafting a preliminary draft of pleadings for their seniors and assisting senior advocates at the bar. The other category that comes to my mind is that of craftsmen as legal professionals, those who refine and craft them into polished legal documents and pleadings, basically forming a compelling legal narrative. These could be the senior members of the bar probably. But in most cases, I also feel that we could be both. We could be thinkers and craftsmen. For instance, I feel like I build my arguments as I write. I keep building on it in my head. And once that preliminary draft is there with me, I polish it up. So I feel like I switch roles in between. So I want to ask you all, the panelists that are here with me, starting with you, Baljinder, how would you bracket yourself if at all you had to? And also, where do you and in what format do you think AI can render opportunities to lawyers and law students to enhance their research and drafting skills?
So I think of myself as a critical thinker, and our system is slightly different to yours in that we don't have the juniors that do the work for us and then the seniors to look at it, unless of course you're King's Counsel where Barbara would have a junior. So when a brief comes to me, the solicitors will send the brief and you'll get all the papers, and your instructions may say, you represent so-and-so, here's the papers, or you may say, may have some detail about what you're asked. So I have to approach it in a different way. I have to do my own critical thinking, and that applies from the moment I get the papers right through until I represent somebody in court or write an advice. For me, AI can only ever be used as a tool to help me, and that with an abundance of caution. Okay, I don't know how many of you, does anybody know how AI actually works? Because I have a twofold thing, you see. Whilst I'm at the bar, I'm also doing a master's in AI and ethics at Society in Cambridge. So it's based on the data sets that it's fed into. A huge amount of that are Wikipedia and Reddit. Okay, it can't create original content. It creates predictive content based on its learned data. So it's entirely dependent on the data sets that it's been given. It can't create original thought, and it can't create context. And when you're family lawyers for us, but I'm sure in every area of law that you do, the context of what you do is really, really important. The human touch, the ability to think, they're all vital. And I sat through a 2-hour lecture at Cambridge trying to understand the maths of how it works. So I'm going to explain it in a very simplistic way. Okay? You put in a prompt. Your prompt is turned into a numerical code, and by a concept called vectorization or matrix multiplication, it all becomes numbers, and then it produces an output based upon its trained data. Okay? The bit in the middle, they don't really know what it's doing. They'll call it black box. You may have heard that expression or not, where we really don't know what the output is. And if you try and ChatGPT to put in the same prompt a number of different times, it will give you slightly different answers each time. Okay? So you've got to be super careful, and I'm sure we'll go on to deal with case law, because there is case law developing in England about the use of AI, about just how hard judges are coming down on barristers in terms of using it in an unethical way. My view is, I have a ChatGPT account. I'll use it occasionally. I will never upload any personal documents for clients, because, of course, their data becomes then the training data that these models are fed on. There's a huge issue of privacy. Use it to help you. We have legal AI tools in England, but you've got to double check absolutely everything that it does, because it hallucinates.
That's great. I mean, you've sort of simplified how AI actually really works, right? And also indicated the issue of privacy, and how even in UK judges are probably, and we'll discuss more on that. I want to actually talk about that in the Indian context also. What about you, Barbara? What do you have to say about, how we can use AI to enhance our skills, at the same time keeping in mind the caution that, Baljinder has just pointed out?
So I think for context, I should say that I'm chair of the Bar Council of England and Wales, so I represent 18,000 barristers. And that's important because, as you know, in England and Wales, we have solicitors and we have barristers. Solicitors are working in firms, they're the first port of call for clients, and they're doing kind of more client care and client handling. We're specialist advocates and advisors. And so we tend to also be the ones who go into court. That context is important, because the other thing about our system is that the 18,000 barristers that I represent, about 14,500 of them are self-employed. So like Baljinder and myself, we're self-employed and we work in the chamber system. The others are employed by banks, the military, the Crown Prosecution Service, the government. So some of what I say is really goes to the self-employed barristers, because those employed barristers will have their own checks and balances within their organisations, and solicitors will have their own checks and balances. The difficulty that we have as a bar council is that our members, the majority of our members, are self-employed. So there's very little that we can make them do. Everybody does their own thing, even in our chambers. So Baljinder and I are in the same chambers, and I'm the head of those chambers. I may never use AI. Baljinder's in Cambridge learning about AI, so she might use a lot of AI, and both things can sit comfortably in the same chamber. So that's our first tension, is that most of our members do their own thing, can do their own thing, want to do their own thing, and I have no way of stopping them. So that's our first challenge. I think, generally speaking, though, what we've done as a bar council is issued guidance. But what we've come to understand is that AI moves much faster than any guidance, because as soon as the ink is almost not dry before AI can do something else. And so generally speaking, what we're saying is, to Baljinder's point, it's a really useful tool. It's a useful tool. Like when I started practicing, practitioners would record on their dictaphones and then someone else will type it, and then we had these things and we were typing ourselves. So we've just moved on in tech, so it's useful, we have to use it. You'll get left behind if you don't use it, but you have to be cautious for all the reason Baljinder says. You're not talking to another human being. It doesn't know the context, it doesn't know the nuance, it doesn't know the human touch. But a lot of the cases that I do have got a sort of paper heavy, so 40,000 pages or whatever. One of the ways in which you can use AI, if you're using a safe model, is for it to help you with, say, the chronology. Put the dates in order, but you always have to check it. I've never done anything with the limited amount of AI that I've done and just relied on the AI product. I always double check it. And I think those who have fallen foul, whether judiciary, whether barristers, whether solicitors, wherever they are in the world, have been the ones who've relied on AI like it's the truth and not checked it. So I think it's there, we have to use it, but you have to use it with caution and intelligently. It's just like as a leader, as Baljinder said, juniors do most of the legwork for me. I'm very lucky. But I will check it. Or I'll ask them to check it. We have a discussion about how they've reached their conclusion. I don't just rely on it and stand up in court and it's not quite right. It's the same sort of thing.
Right. So it's like a supplement.
For sure, it's a supplement. And there's some cut-throughs, and we can't ignore it. Right. I think those who will fall by the wayside are those who don't come up to speed with AI, but you use it at your caution. And you've got to have the idea of, actually, Baljinder said, it doesn't know the context, it doesn't know the nuance, so be careful.
Which is what the Chief Justice of India also said, it doesn't have empathy. It, goes beyond the reach of AI and algorithms.
And it can only do the extent of what it knows.
Right.
So it's got that bias as well.
Because it's trained on data sets.
Yeah.
Gurpreet, what do you have to say?
Sure. Thank you. No, I think I probably mirror a lot of what has already been said, especially what Barbara was talking about, how AI is, as you said, sometimes you sort of lay down a rule or a practice and AI is already ahead of it. I mean, even this discussion today, I know for a fact there are a lot of lawyers in our High Court who are already using AI tools to do tasks which maybe seem menial, making a list of dates and events, right? You've prepared your petition. We have a rule in our High Court that writ petitions have to be accompanied by a list of dates and events. In the past, perhaps that task would be delegated out to a junior member in the chamber or in the firm or wherever you're working. Now that same junior is probably taking your petition, putting it into an AI tool and generating a list of dates and events. I mean, I think most people would know someone who's done this. That's my view. But again, it's a question of caution. I was told once by someone quite senior in the profession that even if you're doing that, you still need to go back and check, because the way that you present that list of dates and events, albeit it's generated by an AI tool, that will also make a difference, right? As you said, it doesn't have context. So ultimately, the list of dates and events is part of the pleading that's going before the court. And some people want them crafted in a particular way, some people want them crafted in a different way. So I think that's important. I do feel, though, that the attitude that we have should be one in which we embrace the technology. Obviously, there will have to be guardrails, there will have to be checks and balances. But the idea, at least my view, personal view, is the more you can embrace that technology, probably you can find ways to better serve your clients. That's the way that I look at it.
Can I just ask?
Please.
Yeah.
So I agree, but how do you, when AI is moving so quickly, how do you both embrace it and have guardrails? What do those guardrails look like?
So I'm not sure if I'm qualified to answer the second part of the question. But the first part, I'll give an example. I know someone who's mildly dyslexic, and he's struggled his whole life. I mean, he's passed the bar exam, successful lawyer, but mildly dyslexic, and he has struggled with drafting his entire life. There's nothing new to it. It was a revelation to him when he first started getting dictation software, which was directly putting his dictations into a word processing. And now with AI-powered dictation software, it's not a hurdle to him anymore in the way it was, 10 years ago. So, I mean, that's one very specific example. But, there are other things. Another one would be a lot of what we do in our High Court, just because of the variety of languages that we deal with, is translation softwares, which are AI-powered. Again, at the end of the day, if you're submitting a translated document in court, you have to satisfy yourself that the translation is correct. But there was a time when, a petition might get delayed by a day because you've had to go to a third-party vendor to get a document translated. Now, if you can at least sort of get a first draft of the translation and maybe back it up with whatever the third-party vendor who's giving you that translation, ChatGPT or Gemini or whatever software you're using, can give, assuming it's a typed document. If a handwritten document in Hindi or Punjabi might be difficult for them, but a typed document in a vernacular language, I think there are AI tools which can definitely help you with that. So, I mean, they're very small and specific examples, but like I said, my view has always been to try and embrace it and use it as responsibly as is possible.
I just add to that. I don't think there's any choice but to embrace it. The genie is out of the bottle. I've had cases where, so I've two this year, where earlier in the year I had a right to a medical treatment case where a baby was very seriously ill. The doctors wanted to do a particular kind of treatment. The family objected. And they objected on ethical grounds because they didn't believe in medicine. And my solicitor really didn't do very much other than be a postbox. And I was having information sent to me directly from the client that was very clearly from ChatGPT, with the client saying, I want you to say this case, I want you to say that case. And I was very firm and said, no, unless I know this case exists, I am not saying that. You have a choice. Either you represent yourself or you let me do it my way. I've been doing this for quite a long time, so I have the robustness to put my foot down like that. Just a few weeks ago, I had an appeal in the Court of Appeal from a litigant in person where she hadn't been able to get funding, where her appeal had clearly been generated by ChatGPT, including all of the documents. Now, appeal was dismissed at the permission stage by the Court of Appeal, but we can't ignore it. It's here, and all of our client base knows it's here. So if you ignore it and you pretend it's not there, we'll be left in the dark ages. We've got to evolve, as Barbara said, in the same way we've always evolved.
That's so right. I think to evolve is, to really summarize that, it's there and we need to catch up with it. But from what I understand from all three of you is that there needs to be a balance. There have to be checks and balances. And so, coming to the leadership of the bar, talking of bar associations, bar councils, how do you think that we are embracing this, the leadership in the bar and guiding this tech change for the legal fraternity? In fact, Barbara, you mentioned that, you have some guidelines at the Bar Council, to navigate the growing use of AI and other generative tools. Can you throw more light on that? What are those guidelines? Do you have anything specific? I also understand that you said that you can't really bind down, the barristers and the solicitors. But to what extent do you think that, these guidelines can be enforced?
Well, I think what we can say to them is be cautious, otherwise you'll use it in a court setting and you'll get burnt, because that's where you're going to get problems. Either you'll prepare a whole case on the basis of AI hallucinating, in which case and in our jurisdiction, there are cost consequences. So if you bring a case that has no merit because you relied on AI, it's going to cost you. So it'll cost you not only your own client's fee paying you, but it'll cost you the other side's cost. So that's really salutary. But here are some of the guidance that the Bar Council has put out. So effectively we say, use it, it's there, the genie's out of the bottle, as Baljinder says, but do it with care. And we've got an ethics and regulation hub on our website, and we set out the key risks. So what we do is we say use it, but be cautious. And here are some of the things that you might want to bear in mind as things to really think about as you use AI. So that's the best we feel we can do at the moment. So we set out the key risks with using LLMs, hallucinating, information disorder in data training, and we explore considerations for practitioners when using LLM systems. So we say, for example, due to possible hallucination and biases, it's important for barristers to verify the output of LLM software and maintain proper procedures for checking generatory outputs. We tell barristers about the black box syndrome. the LLM should not be a substitute for the exercise of professional judgment. We tell barristers that they should be extremely vigilant before they share on any LLM system legally privileged or confidential information. We tell them that you have to critically assess whether content generated by LLM might violate intellectual property rights, and be careful not to use words which may be in breach of trademarks. We tell them to keep abreast of the relevant civil procedure rules, because the court set out the use of LLM and stuff, so they might have some guidance there. And so we explain what it is, where the risks might be, and say be cautious. And that's all we can do.
That's great. I mean, just to reiterate everything that you said, very, very valid points on maintaining privacy, client confidentiality, and privileged communication. Whatever you're feeding on, whatever tool that you're using, is obviously training the model on that, And to maintain the privacy of your client, you're bound by it, right? So all of these things are to be kept in mind by all of us lawyers every time we use any generative AI tool to work on our matters. I think that's very, very valid. Gurpreet, would you like to?
I was just going to say, if
something from the, I think another important thing that Barbara brought up was protection of IP. Right? I think that's very, very valid, which we don't really think about. But I thought that was very interesting.
So I think just before that, if I remember correctly, and maybe someone can check me on this, if I remember correctly, a few months ago, OpenAI released a statement to say that your communications with ChatGPT are not legally privileged. So, I mean, that is the first and foremost, we were talking about God, is that it's not a closed data set. They will, whatever you upload onto ChatGPT and whatever response you get is not legally privileged information. So if suppose you're uploading a petition to make a list of dates and events, don't be surprised if your petition is now part of ChatGPT's training data set for the future. Now then the question then, as lawyers, you have to ask yourselves is, did you have instructions from the client to release their petition and their details into the ChatGPT training set, right? If it is not legally privileged information. So I mean, that's one way of looking at it. The other way, of course, is I think across the world, in New York, even in New Delhi now, OpenAI is facing lawsuits from news publishers across the world on how much they own the information that they're giving you, right? I mean, the last thing you want is to be using information from, I mean, we are singling out ChatGPT, but any LLM, any large language model, do you want to be somehow contributing or being part of contributory infringement of copyright if you're using information that is being given to you by an AI software and it turns out that the training set had copyright protected information within it? I mean, that's another red light, to look out for. I know that even in India, there are AI softwares which are using closed data sets, so that risk is minimized to an extent. But a lot of this is, you need to be careful. We go back to the legal principle, caveat emptor. If you're buying a subscription to AI software, you better know what it is that you're buying, right? What are the rights and responsibilities? What are the T's and C's actually involved? I think that's one thing we definitely have to be careful of.
But even the
guidelines on the Indian front, do you see any bar council or association in India?
I think we might have some members of the Bar Council here. They can probably help answer. But as far as I know, there isn't anything yet from the Bar Council. And in fact, that was one of my opening remarks, is perhaps it's time for us as a community to start self-regulating how we use AI before there is some sort of a judicial intervention. What I anticipate is at some stage, a judge is going to come across a pleading which has a citation, which is a hallucination, and take the opportunity to start regulating how pleadings are presented. I wouldn't be surprised to see if judges now start mandating that you make a declaration whether a particular petition or a particular pleading has been prepared using ChatGPT or not. So, before we get to that stage, probably a good time to think about self-regulation.
And just picking up on what judges may do. So we had about a year and a half ago, I think end of 23, early 24, guidance from the Bar Council. The judges had guidance too, and that's been updated earlier this year. But what put the fear of God in every barrister was a case called Aynd and Al Haroun that was heard in a Hamid hearing by the High Court judges back in June. And a Hamid hearing is a disciplinary and cost hearing against barristers. And they heard two cases together. And one was called Aynd and Haringey. And the facts of that case were that somebody wanted some housing, the local council hadn't given housing, and it was a judicial review. And the lawyer relied on cases that didn't exist. So she had 5 cases which she cited, and they couldn't find them on any platform. And she never owned up to using AI. She said she had a list of cases in a resource somewhere, and she transferred them across. And the High Court clearly didn't believe her. In the Al Haroun case, Mr. Al Haroun had sued somebody for 84 million, and he had sent his solicitor, I want you to rely on this, and these are all the cases that I want you to use, and the solicitor hadn't checked, so he just issued with all of these cases. And again, the cases didn't exist. Okay, High Court slapped down hard in terms of using it as a general warning to the whole bar and solicitors and the legal profession about what you're doing. And there's a very important judgment which I'm happy to share with you, Gurpreet. But in terms of what they said about what the court's powers are, they said the court has a range of powers to ensure that lawyers comply with their duties to the court. Where those duties are not complied with, the court's powers include public admonition of the lawyer, the imposition of a costs order, the imposition of a wasted costs order, striking out a case, referral to a regulator, the initiation of contempt proceedings, and referral to the police. And then they said the court's response will depend upon the particular facts of the case. Relevant factors are likely to include A, the importance of setting and enforcing proper standards. B, the circumstances in which false material came to be put before the court. And the court's dealing with this on the basis of you put a false citation, you are providing false information to the court because it is your duty as an advocate to ensure that what you are doing is correct. C, whether an immediate, full and truthful explanation is given to the court and to other parties to the case. D, the steps taken to mitigate the damage, if any. E, the time and expense incurred by the other parties to the case and the resources used by the court in addressing the matter. F, the impact on the underlying litigation. And G, the overriding objective of dealing with cases justly and at proportionate cost. And certainly guidance was put out to all heads of chambers saying, your responsibility to develop your AI policies. And certainly in my chambers, it was, you know a bit about AI, you need to draft this policy. Yeah, it's still in my list of things to do. Because although barristers are all self-employed, we belong to a chambers. And if there is a disciplinary issue about any one of us, it goes to the heads of chambers and our regulatory bodies, and it reflects badly on the chambers. I'm not sure how you practice here, whether you are in chambers or as individuals, but in the UK, inappropriate use is being slapped down very, very hard. At the end of the judgment, it's a really useful judgment to read, and I will share it with you all. There's an appendix, and they set out similar hallucination issues that have arisen with the cases cited in the United States of America, Australia, New Zealand, and Canada. Now that's probably tip of the iceberg in terms of what's happening. ChatGPT, I personally would not go near for any kind of legal research for one of my cases because I'd be really worried about the privacy issues and uploading confidential information and the hallucinating. In the UK, we have legal platforms that have developed closed vaults of AI. So we have something called Lexis AI, we have Thomson Reuters OA. So Lexis have got a platform called Protégé, where we haven't used it yet. We're about to try all these systems as a chambers to figure out whether we wish to use them. They say you've got a closed vault. You upload your papers and your instructions, and it can produce chronologies for you, hyperlinked to the pages in the bundle. It can produce a comparison between statements and comparison between expert reports. My concern about that, and I'm really sitting on the fence in terms of whether I want to use it, and I think Thomson Reuters is the same thing, but they're just called co-counsel. If I have to double check everything, is it adding to my work or reducing my work? Okay, and for me, it's context. I don't know if any of you play Risk. For me, my job is a little bit like a game of Risk, in that you have the board and you get a set of instructions and you are for a party and you need to present a case. And your hand may be really rubbish, but you've got to look at what facts help you. If you've missed all the context and got a generic chronology, other than the very basics, how can it possibly help you? So use it as a tool. As I say, as a Chambers, we're going to trial them both. We're in talks with both companies to see whether they're useful to us, whether we want to invest in it. You've got to be aware of what's happening. You can't ignore it. But ChatGPT, and that's obviously there's Claude, there's Grok, and there's a whole host of them. I'd be very, very careful about going near any of them with any of the legal cases.
Yeah, I just think that with what you find when you look at all the reported cases, not just in our jurisdiction, is that what offends judges most is using AI and not fessing up as soon as possible that you've used AI. So in one of the cases that Baljinder referred to, that barrister went to quite a lot of trouble to hide the fact that she'd used AI. Even at the hearing, she couldn't bring herself to say that she'd used that. Even at the disciplinary hearing, she couldn't bring herself to say that. I suspect that when she submitted those papers and the solicitors on the other side said, wait, we've never seen these cases before, if she'd said, oops, made a mistake, it was AI, it might never have got to where it got to. But she doubled down and doubled down and doubled down, and I think that was the problem. Because all of us as lawyers have a duty of care to our clients, and we're officers of the court in England and Wales. So our first duty is to the court to tell the truth. So, we can't have that.
It's actually the same here. We are all officers of the court, and as
Yeah.
you rightly said, our primary duty is to assist the court, right? Of course, keeping the interest of the client in mind, but yes, as officers of the court, these are some concerns that we all need to keep in mind as lawyers. One aspect that I want to finally touch upon is the aspect of actual usage of AI in courtrooms, in judgment drafting and in writing down of orders, right? In fact, our own High Court has had a very interesting case in 2023 where one of the judges, while deciding a bail matter, actually referred to ChatGPT. For arriving at the findings. So just for everybody's reference, we've got a copy here, and I'm just going to briefly read out. If you see para 9, page 3, it says, to further assess the worldwide view on bail when the assault was laced with cruelty, the use of artificial intelligence platform which has been trained with multitudinous data was made. The following question was put to ChatGPT OpenAI, and if you see, he's footnoted the entire chat as well, just for transparency. And he says, what is the jurisprudence on bail when the assailants assaulted with cruelty? And of course, the response is, made part of the order. And then para 11, it says, there is a big disclaimer here in the judgment as well, but it says that any reference to ChatGPT and any observation made herein above is neither an expression of opinion on merits of the case, nor shall the trial court advert to these comments. This reference is only intended to present a broader picture on bail jurisprudence, where cruelty is a factor. So it's interesting to see that, judges are also sort of, the desire to not being left behind and, using these tools. Of course, they don't want to use this to form their opinions on law, right? But I thought it was a fair thing to, just let everybody know that this was used, right? On the other hand, there are instances that we've just discussed of hallucinations, which you've also pointed out on the output of generative AI. For the easy reference of all of us here, the audience, I'll just briefly explain what do we mean by when we say hallucinations in terms of AI. So, these are basically instances where AI tools generate outputs that look factually very plausible and convincible, but they are actually incorrect, right? So, in a legal scenario, as you've already seen, Baljinder has explained, there can be very serious legal consequences for these. So, I want to start with you, Gurpreet. Do you have anything, something similar to what Baljinder has shared? Anything that you've come across in your practice, where you've come across these hallucinations, or if the court has flagged out anything in any matter?
So I haven't yet seen the court flagging a petition which has a case cited with a hallucination. I have, and I'll be very careful in what I say, I have seen an order in which a case was cited and the quotation from the case did not actually exist in that case. It was on a minor point, and when the matter went up in appeal, the appeal was not decided on that issue. But I have seen recently a case where an order was passed by a judge citing a case. The citation was correct, but the content of the judgment that was relied on did not actually exist in the judgment. So that made me think, what kind of a framework can we use now to deal with this? And I go back to sort of first principles. When you're studying law and you're told to go find out a particular legal point, the first thing we were taught initially is go open the reference books, right? See what other people have written about it. But even then, you don't go back to your professor and say, okay, here's what so-and-so has written about this point. You will look at the cases referred to in the commentary, actually open those cases, and then try and figure it out. So I think it's the same thing perhaps with ChatGPT or with any other software. If they're suggesting a case for you on a particular point, go find the case itself and see what the case actually says, rather than whatever summary comes up for you.
I entirely agree, and can I raise a different issue that we haven't touched upon yet, which is human in the loop? And I don't know whether your case was appealed, but in England somebody would have argued judges need to make judgments, not ChatGPT, otherwise what is the point of a judge? And I know because I've got there's another lots of chambers in London, but there's education chambers, or chambers that does education, called 3PB, and I know one of their barristers earlier in the year was running a case in a special educational needs tribunal. So in England, if you have children with special educational needs, you can have particular kinds of support. And the response to it had been generated entirely by an LLM. I don't know whether it was ChatGPT or a different one, but they hadn't used a human to reject the claim. And I know it was being appealed on the basis of this is not a fair process. There is no human making a decision anymore. I don't know what the outcome of that case is going to be, but I think it's really important to look at it not just in terms of hallucinations, but you're entitled to have people who have an expertise in their field making decisions for you, rather than the answer the LMM has thrown out.
Over here, quite literally, one of the grounds in appeal would be non-application of mind, because quite literally a mind was not applied to the case.
I don't think I can say much more but agree with my colleagues here, except to say I find it even more worrying that a judge would use it, because unlike a barrister or counsel using it, at least it's going to go before a judge, but a judge's decision that isn't appealed is just left there, and who's made the decision and so on. I know that I was at the Commonwealth Lawyers Conference in Malta in April of this year, and I know there that some people, I wasn't in the discussion because it was just judges, but some judges in some jurisdictions are now writing entire judgments with AI. I mean, I think that's just a disaster, And also, I know, because I sit as a judge, in England and Wales, you're allowed to sit as a judge as well as be a practitioner. So 6 or so weeks a year, I sit as a judge, as a deputy in the High Court. And I know myself, and I only do family cases, that sometimes the decision-making happens as you write the judgment. You've heard the evidence, you've got the facts sorted out, and then you're thinking and writing, and it develops. I mean, a lot of the time you know what you're going to do, but sometimes it develops. So I'm not sure what AI is doing.
So this goes back to the where I started from, right? Thinkers and craftsmen, right? Like you write and you think and develop your drafts and your pleadings and whatever it is that you're working on. So I'm going to wrap this up, right? So a lot of serious issues we've seen been flagged, and I see a lot of commonality in a lot of concerns also, in India and with what you guys face back home. Of course, client confidentiality when we are using whatever tool that you're using, right? Use it as a supplement and not really as an entire draft. And as Barbara rightly said, without proofreading it, without double checking it. Although I do also understand Baljinder's point of view, if I have to double check everything, I might as well do it myself, right? So, of course, I think it was very interesting, and I think it was beneficial to all of us here. Thank you so much. I want to tell everybody that both of them are on such a tight schedule, and you've taken out this much time. It's really great, and I'm glad that we could, sit and chat. Yeah, please.
I just wanted to say just one more thing, which is that the Bar Council of England and Wales and the lawyers in India generally have had a very long and warm relationship. One of the things we know is that the challenges we have are the challenges you have. And I also know that often we come to the best solutions when we work together. And so I would be very interested on behalf of Bar Council of England and Wales to collaborate with you. I heard you say, Guppy, that you're not yet at the guidance stage. So when you come to think about it, you'll have examples that we don't have, we'll examples that you don't have. So actually collaborating means that we get to a stronger global legal profession. So I'm very, very happy to be able to do that and offer that to you if it is of use to you.
No, I think one of the great things that we can take away is the guidelines, for instance. We can start with that as a reference point, right? Yeah, I think that is something that all of us can go through and, maybe just have as a reality check for all of us. And I want to thank the Bar Council of Punjab and Haryana also for taking this initiative and organizing this event where all of us could benefit.